attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. All Regulation A offerings must be at a fixed price. That is, no offering may be made at the market or for other than a fixed price. Moreover, no part of a Regulation A offering may be variably priced. Accordingly, Regulation A cannot be used to qualify shares underlying variably priced derivative securities, such as convertible notes or warrants. It could be used if the securities convert at a fixed price. Regulation A cannot be used for indirect primary offerings. Accordingly, a Regulation A cannot be used for an equity line of credit or ELOC, even where the company's put options are at a fixed price. Though at this time, this interpretation is based on SEC staff prerogative and could change without a formal rule change. Any staff interpretation in this regard would hopefully address whether an indirect primary offering would nonetheless be considered resale and therefore limited to 30% of the total amount of securities included in the offering circular. Since Regulation A is treated as a public offering, broker-dealers acting as placement or marketing agent are required to comply with FINRA Rule 5110 regarding the filing and approval of underwriting compensation. Securities issued to non-affiliates in Regulation A offerings will be freely tradable. Securities issued to affiliates in a Regulation A offering will be subject to the affiliate resale restrictions in Rule 144, but not the holding period restrictions in Rule 144. The same resale restrictions for affiliates and non-affiliates apply to securities registered in a Form S-1. However, since neither Tier 1 nor Tier 2 Regulation A issuers are subject to the SEC reporting requirements under the Exchange Act if they only report under Regulation A, the shareholders of companies that were once a shell company at any time in their history would not be able to rely on Rule 144. Moreover, the twice-a-year Tier 2 reports would not always constitute reasonably current public information for the support of the use of Rule 144. Current information under Rule 144 requires that the information be no more than 3 months old. Tier 2 companies that file a Form 8A and become subject to the Exchange Act reporting requirements are therefore subject to the Exchange Act reporting requirements and may use Rule 144 as any other Exchange Act reporting company may. Also, a Regulation A reporting company can opt to file quarterly reports using a Form 1U and thereby maintain current information. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.